Let me just add to that. Some people might wonder why are we filing in Albany County Supreme Court when this issue is a New York City issue. Of course, it's not only a New York City issue, it's a New York State issue, it's a nation issue. But by law, we're required to file the case in Albany County, where the Commissioner of Education works out of. And Norman pointed out that this might be a case of first impression. Well, it might be a case of first impression with respect to the particular facts here, the granting of a waiver and so forth. But the precedents that govern what was done here are long-standing precedents. They're long-standing. And in a nutshell, what they say is that when a statute is clear, when regulations are clear, an administrative official cannot exercise his discretion in a way that is inconsistent with what's contained in the statutes and what's contained in the regulations. And in the lawsuit of the people behind me, what we say is, and we think it's abundantly clear, no one's ever challenged it, that the education law is very clear and the regulations are very clear. And they're clear to the point that we believe that what was done here was not only a travesty from the viewpoint of 1.1 million children, but it was illegal.
Just going to take her question and then we'll come back to you.
Hey, I'm Laura from City Hall News. Did Chancellor Klein meet all of the requirements listed in the statute?
Chancellor Klein did not. However, Chancellor Klein had more education credentials than Ms. Black, and if Herb and I were around and focused on this issue, we could have gone in and challenged. And if it's raised in the court with regard to precedent, the answer will be that on reflection to the waiver for Mr. Klein, that did not meet the statute and the regulations either, but he had more credentials than Ms. Black. For example, he had a Juris Doctor, which they said was equivalent to a master's. That's a Juris Doctor for law school. I believe he went to Harvard Law School. He taught for 3 years at Georgetown Law School. He taught for a short period of time in 1969 math in a public school in the city of New York. And also he was a graduate of the public school system in the city of New York. All of the above, Ms. Black does not have.
Besides that, of course,
The law changed.
the fact that the Commissioner of the Department of Education appointed people in the past who might not have satisfied the statute doesn't make this appointment legal. Just means that they have repeatedly violated the statute. The difference is, this time, they were caught.
Just to follow up to your previous question, your response, what will happen if you win the lawsuit on the 23rd and Chancellor Klein's tenure expires on December 31st? There's no one to replace him. So what would your goal be? Because I'm assuming you'd like to win the lawsuit, but not have no chancellor. So.
Well, the answer is if we're successful, the waiver will be nullified, and the system will have someone to be the interim person during that period of time. So what's most important is to follow the law, which we submit is not being followed at this point.
So, I'm sorry, so who would that interim be?
We don't know the answer at that point. That would be up to the mayor to make that decision.
Can I just interject and say that
Come to the podium.
if there's one classic example of the failure of the management approach, it's the fact that after 8 years of leadership of Chancellor Klein, there is no clear successor who has education credentials. The first rule of management is you deal with succession planning. And clearly, they have not done that because they prefer to go with the whim of the mayor than with dealing with quality education.
I think also in terms of succeeding, the mayor has chosen somebody as number 2. Mr. Shel Polakowski might be the interim acting chancellor. Not by law, but that would make sense to me.
And presumably Rupert Murdoch can wait another month to get Joel Klein on board.
Not when there's money to be made.
Yes, please identify
Downtown
yourself.
Express the Villager. So,
Can't hear you.
sorry, Aline Reynolds from Downtown Express the Villager. So, could this decision theoretically be made after the fact, after she is brought into office? And then what would happen?
Well, the fact that you said theoretically, the answer, yes. Theoretically, it could happen. And, there's also the possibility of, hypothetically, if we're successful, that the Department of Education decides to appeal the decision. And they could take it to the appellate division. And then if we were successful there, they could even go to the New York Court of Appeals. So you could have a decision that is appealed and ultimately final at a time subsequent to January the 3rd. And you have examples in other areas where a decision is made after January 3rd, and the nullification would then take place whenever the final decision of the court was. The courts have dealt with issues like this in other contexts on numerous occasions, and I am confident as an officer of the court that the court can deal with that situation.
But just to confirm, the lawsuit doesn't specify an interim, a candidate, an alternate.
Absolutely not. That's not our position. The focus of the lawsuit is to challenge the government officer's action, and we ask for a declaration that it was made in violation of the law and the regulations, and it asks to nullify the waiver, and that's the extent of the relief that we ask for, and that's appropriate. And in Article 78, it's a special proceeding that is expedited, and the reason why you use an Article 78 is because you can move the legal process in an expeditious manner because it is a special proceeding. And when I began, and if you read our memo, it starts off by saying the facts in this case are not in dispute. And that's very important. So this is a clean question of law and interpretation of the statute and the regulation, and it's our position that Steiner misinterpreted, misread the statute and the regulations, and that's what we asked the court to do. It's not going to be a hearing where you're going to have discovery prior to, with transcripts and testimony taken prior to the case. It's not going to be the kind of thing that you see on TV with witnesses sworn in before a jury. It will be on December 23rd, one judge with some lawyers arguing both sides of these issues of questions of law.
One thing is important to bear in mind. It's not that Norman Siegel or Herb Teitelbaum are saying that Ms. Black is not qualified. And in fact, while our clients take that position, it's the legislature who said that she's not qualified. And it's the Commissioner of Education who said she's not qualified in the regulations. And as I said before, this is a bold end run around the legislation and around the regulation.
Any further questions? Okay, thank you, everyone. Thank you for